Okay, so without any further ado, we ask Steve Schwarzberg.
If you can hear me, the nice lady in the red dress and black jacket, up so I can see that you can hear me. Hey, like, good morning. Thank you for letting me appear via webcam. I'm in Columbus, Ohio. Today is Lucky Lawyer Day, so I want you to know I can feel the love of coming through this webcam. The first topic, I have a feeling the two topics will meld in together. It's not going to be a presentation on cannabis and sex, politics, and religion. Those are two separate topics, so I don't want anyone to be confused. When Halloween just having occurred, I wanted to think about dressing up for the presentation, but I couldn't think of how to do that. So because of speaking about cannabis and employment law, I decided to have a brownie this morning. So I hope that the presentation will still be LOC. That was a joke. So and you all know, a growing number of states have passed legislation allowing medical use of marijuana, and an additional number of states are allowing recreational use. And it presents very complex problems for the employer in the workplace, and especially for those of you who may have multi-state businesses. You're going to have to try to figure out how to navigate through each state's law. And what really presents the biggest problem is that the use of pot is prohibited nationally, federally. So it's still a federal crime to be involved in the growing, sale, use of marijuana. President Obama had issued an executive order which was called the Cole, C-O-L-E, the Cole memo, which basically directed the Department of Justice not to enforce any federal laws so long as the state allowed the actual use of the cannabis, the marijuana. And maybe that the Trump administration, through Jeff Sessions, removed and vacated that memo and has left the door open for possible threat. Use, etc. So it's heading in the direction, the trending obviously is heading in the direction of people being able to have medical use and more states allowing recreational, but the federal government not prosecuting. The reason I'm mentioning this is because it actually impacts on employment law issues. For example, the Americans with Disabilities Act, if someone has a medical authorization in a state that allows them to use cannabis for medical purposes. For example, Florida has a statute, 381.986, and that statute lists various conditions that an employee might have, as a qualified employee, for to be allowed a prescription. Cancer, glaucoma, epilepsy, HIV, post-traumatic stress disorder, ALS, Crohn's disease, Parkinson's, multiple sclerosis, terminal cancer with a certificate from a doctor, non-malignant pain, and the list is non-exclusive. So, as you can see, there are many, many conditions that a person might have that might qualify them for being allowed to have medical use of marijuana. And then the question becomes, does the employer, what employment laws apply to a situation where someone is so qualified? Here you have a state statute that allows that person to use cannabis and you may have employers who may not want to hire or may want to fire employees who get such medical certification. The statute itself that I saw does not have specific provisions prohibiting discrimination, but some court decisions have already come down in other states saying that when a state passes a law that says that this kind of use is allowed, there's a private cause of action by an employee who suffers adverse employment action when an employer decides that they don't want to hire somebody because they have such certification or the employee gets such certification. So, and then the different states, as you know, have different kinds of provisions, and some states have no provisions at all. So, with regard to the hiring and firing, it presents some challenges to the employer. Plus, let's just look at ADA by itself. The Americans with Disabilities Act is a federal statute. So to the extent that federal law prohibits the use of cannabis, on the federal level, that an employee doesn't have the benefit of a statutory protection scheme such as the Americans with Disabilities Act on the federal level. And yet every state has a Civil Rights Act, which actually mirrors, often mirrors the federal statutes, if not word for word in substance. And each state has an anti-discrimination statute with regard to disability. So here in Florida, you have a state statute allowing medical use, and you have the Florida Civil Rights Act, Chapter 760, which is our version of the Federal Civil Rights Act, Title 7, which would protect people from discrimination based on having a disability. So to the extent that, ironically, on the federal level, if the federal level may not afford protection under the ADA, yet the state Civil Rights Act may very well provide protection. So you have that tension. So why are we talking about this? You probably sensed from reading and hearing articles about the exponential growth of the cannabis industry. So you have employees working in the cannabis industry, but you also have a lot of employees who are going to be users of medical or recreational. I can tell you something that's important. Whatever laws may apply or not apply, employees can be prohibited from using cannabis in the workplace. Employers can prohibit employees from bringing cannabis onto the premises, the work premises, to the extent that authorized medical use is permitted in that state. An employer can reassign an employee if there's a question or issue with regard to safety. Is that the employer is allowed to prevent that employee from doing harm to himself or herself or others if there's use that may impact performance at work. So, but then it raises back questions as to whether that's really the case or not, and it could lead to a lot of litigation. So let's talk about the exponential growth of what we're talking about. I'll read some statistics to you. The total number of job postings for the cannabis industry, that's in the industry, increased 445%. According to Forbes, there are now somewhere between 150,000 and 250,000 jobs in the cannabis industry. The reason they don't know how many is because the person who did the calculating was high. They forecast those numbers rising to 1.1 million by 2025. If you want to get a sense of how large the industry is now, the number of people in that industry is larger. The number is larger than all the bakers in the country, and larger than the massage therapists, and larger than the number of dental hygienists. So, and it's growing rapidly. It's one of the fastest growing industries in the country. There are now 40,000 cannabis businesses, and that will rise to 150,000 in 5 years. 40 states and 25 countries have legal cannabis laws. 192 million cannabis consumers worldwide. That number is expected to rise to 300 million in 5 years. So it's huge. What kind of people in the industry? Very dispensary staff. They have instead of bartenders, they have a bud tender, trimmers, edibles chef, extraction technician, master grower. The employment fields are related to the industry. Cannabis companies across all product and service lines. IT, software, marketing, advertising, web development, human resources, law, accounting, business, management, medical, nursing, healthcare, etc. So the industry is growing. What's the legal background? I commented on some of it. Marijuana on the federal level is still considered a Schedule I controlled substance. So it's an illegal substance, and there's no basis in the federal law for it to be used. It has to be reclassified to Schedule II, or something like oxycodone, where it's allowed, but it has no impact or effect. But that hasn't happened yet. And the current administration, with Jeff Sessions as Attorney General, has spoken out vociferously against use of pot. It's unlikely that would happen. So the federal government doesn't allow any such businesses. So we're in a situation where if someone's doing business in cannabis in a particular state, it's still possible that the federal government might swoop in and seize all of the assets of that business. That it can do even without criminal prosecution. There are banking laws that are implicated. There are issues about how money gets deposited in a bank or not deposited in a bank, etc. If you're there's a case that came out recently, and it involved a bankruptcy of a landlord, and the landlord argued in Florida that they could reorganize and they should proceed under Chapter 11 and not liquidate under 13. And the argument was from the debtor in bankruptcy, I have a tenant who's in the pot business, and they're going to be a huge tenant, and I'm going to make a lot of money as a landlord. And so let me reorganize. I think I can come out of bankruptcy and pay my creditor. And the court issued a decision that said that because the source of the money was from an illegal, an activity considered illegal federally, that bankruptcy plan would not be allowed. So the law has not caught up. We're in a state of flux. So it's ripe for a lot of litigation and problems that could occur. And there are a lot of considerations that have to be taken into account when dealing with employees. You're probably thinking about what should we do with regard to drug-free policies that you may have. In a way, you could look at the use of cannabis where it's medically authorized, as you might think about prescription drug use or alcohol. Employers may prevent and prohibit employees from using prescription drugs or alcohol in the workplace, and that won't change. But you have a situation where, in the state law, for example, if somebody has a disability that is alcoholism, alcoholism is recognized as a disability, that person now presents, and the employer may have an obligation to engage in the interactive process to see what kind of people accommodation can be provided so that the employee can continue to be employed. So if somebody is a medical certified user of pot, it may be that, and if they're addicted to it, then the addiction itself may be a disability, which the employer may have to engage in the interactive process in dealing. On the federal level, there's probably not an obligation to engage in the interactive process or provide FMLA or federal statutory benefits, but states they impose that obligation, as I've already mentioned. Getting back to some of the legal issues, you have a lot of it may be, to give you an example, that if a business is involved, if any of you are involved in this particular cannabis area, it may be that you don't have any liability insurance. A lot of insurance policies provide that there's no coverage for any activity that's considered to be illegal. If you have licensure and you're involved in a business that involves pot, you have your license impacted. And there may be issues on tax issues as to whether you can deduct certain expenses on the federal level. So, as you can see, there are a lot of legal and statutory kind of implications that apply generally. Looking at some of my notes, I think an employer may find itself between. On one hand, if you, as an employer, in the hiring process, you decide not to hire somebody because they have a medical certification for pot, you may be discriminated and you may be opening yourself up, either in a state that has specific prohibition against it, or based on case law that doesn't apply right to the employee file such a suit. And then, what if you do hire that person and you have a policy that you just established your business that there's no cannabis? In Florida, it's medical use is allowed. Have you all updated your employee handbooks to provide that even someone who doesn't qualify is not allowed to use any form of cannabis in the workplace or use it in a way where it would adversely affect their performance. So that's something we're considering. But when an employee takes a break, how do you know that they're using cannabis? If they're eating an edible, if they unwrap their brownie, eat a brownie, how would an employer know whether there was cannabis in the brownie? You wouldn't be able to know. So then you see some performance and you wonder whether the employee is actually using cannabis, and maybe you make certain decisions as to hiring, firing, or whatever, and then all of a sudden you're in a situation where maybe you're exposed. What if you don't do something? And then the employee injures a customer or a client or a coworker. Now all of a sudden you may have some exposure for negligent supervision. If you hire someone who's a medical user and you're allowed them to stay in a position where they go on to somebody, then maybe you get sued for negligent hiring. So the employer, it's going to be very difficult for the employer to figure out what to do. In which state is the employee? Are we talking about a federal level, state level? Are we talking about something where there's an express statutory provision in place or not? And you have some common law exposure, as I said, with regard to negligent hiring, supervision, retention, etc. So right now, those are most of or all the comments I want to make at this point with regard to cannabis and employment law. If these kinds of issues come up, I think that you may want to try to speak to an employment lawyer on these kinds of issues more so than you would others, because you've all been educated and trained and you're knowledgeable about the more typical issues, but I think when a situation arises and you're dealing with an employment situation involving cannabis, I think what you do and what you try to do may not be so intuitive, and it may expose your employer to liability if you make the wrong move. So I'm happy to go on to the next topic, but maybe it's a good time to stop and try to respond to some questions. Romeo, what would you like me to do? Speak on the second subject or try to answer some questions now?
Are there any questions on this topic? Steve should be able to hear.
I have a question.
I can hear thank you now. If you speak in a loud voice, I should be able to hear.
I have a question. The use of cannabis, if it's medically,
I can't hear you. Please speak a little louder.
if it's,
I'll read.
Come on, go in front.
So there's a hot seat for you.
Okay. If the employer, is it the employer's responsibility to monitor the 30-day renewal of the cannabis, card? Like if they get it
I-
from a doctor?
That's a good question. I don't know the answer to that specific question. I know the statute very specific on procedures as to what has to happen, but I don't know the answer to that particular question.
Okay.
As to whether the employer has to want to be ruled or not.
Okay, and,
It sounds like it makes sense that the employer would want to know, employer, I imagine, would be reasonable in what to inquire as to whether the continuation of recertification occurred.
okay, thank you.
Thank you.
Are there any other questions or not? There's a couple more, Steve.
Okay.
I work in a drug-free company where, I work in a landscaping maintenance company. We deal with chainsaws and mowers and, big machinery, things like that. And we do have the drug-free company. So if we drug test somebody and they come back with marijuana, there's not really somewhere we can put them where they're not going to affect somebody else. So what do we do about that? I mean,
And
That's
Steve,
a good example.
Steve, if you can repeat that question too, so everyone can hear it.
I heard the question. I'm sorry, you want me to repeat it? Or?
Yeah. No, if you can repeat it.
Okay, so, as I understand the question, this nice lady, what's your name?
Andrea.
Andrea is involved with a landscaping company, and their drug-free policy, and if someone tests positive, they're using dangerous equipment, potentially harmful, and it's difficult to use. And if someone tests positive, and there's no other position they have in the company for that person, the question is, basically, would they be allowed to let that person go under those circumstances? So that's a very good question. It brings into question a lot of the points I've been trying to discuss. On one hand, if someone has a medical certification, they're allowed to use pot, and the mere fact that a person tests positive for pot by itself should not be a basis for terminating the person for the obvious reasons. But if the employer has substantial concern that the fact that the employer may not necessarily know that there's use before the employee comes to work that day or is affected, even though the employee is not using during the work day, if the employee is handling equipment that may harm himself or others, then at that point, there's a real basis that the employer, I think, would be able to not have that employee in question because I think safety trumps everything else. The problem is, it's going to be a fact question. So when that employee is terminated because he or she tests positive, the employee is probably going to have to demonstrate that there was a real substantial reason for being concerned about harm that may occur, and that's going to be a very fact-intensive inquiry. And it's the kind of thing that leads to litigation because there's going to be an employer who's going to terminate somebody, there's going to be an employee who's going to feel their work will be terminated, and there's going to be a lawyer out there to take the case.
Can we require them to show us their usage card, their prescription card?
Yes, you can do that. You can definitely require the employee to demonstrate that they have the certification to be able to use, and that's the explanation why they test positive.
So then my next question would be, if I were to create a piece of paperwork basically saying, this employee has the usage card, and I have them sign it basically saying that I will not use pot during the work hours or before coming to work, would that be something that, could hold up if something happens, we do have to terminate the employee?
Yes, a very smart idea. I think you're heading in the right direction. You're already there. There's no reason why you can't have employees sign the acknowledgement that they may have the certification, but they're not allowed to use during the work hours, and they're not allowed to use close to the work hours if it's an impact in performance at work. And that's a policy. And then you apply it uniformly, and you apply it fairly and reasonably, and then at that point you make a decision to terminate somebody. It's documented, and you have a legitimate basis that you establish. It's not a whim
then, as a drug-free company, if somebody gets into an accident, we are required to drug test them. So if they come back as positive for marijuana, what happens with workers' comp?
But that's a good question. I honestly don't know the answer. That's going to, that's going to be something that's going to be what, in workers' comp and in works.
Okay.
You're helping to raise the actual real life situations where you're countervailing issues. On one hand, someone has the certification and the usage right, and then all of a sudden, and it may be that it doesn't impact their performance, but here there's a drug test that shows a positive. How's anybody really going to know whether they used during the day? Someone's driving a car and they have a little baggie next to them and they're eating a brownie. There's a lace or not lace. There's a lot of situations no one's really going to know.
Okay, thank you.
Thank you. Very good question.
Did you have any other questions, or?
Well, I do have a question. How different is tobacco-free workplace versus this new law accepting medical marijuana in the workplace?
Do I understand your question to be
The difference
what
between
impact do the new laws have on the drug-free workplace?
no, what's the difference between being a tobacco-free workplace versus this new law now with medical marijuana in the workplace? Can we just set up a policy we have zero tolerance being a marijuana or cannabis-free workplace?
So, if what I'm understanding is that can an employer have a policy that they won't hire anybody who's a certified user? Is that your question?
Pretty much.
Okay, it's a very good question, and the answer has not been established yet, but there are some states that have had cases come down where the employee was allowed to sue because they were discriminated against, because there was a state statutory scheme allowing medical use of marijuana. Some of the statutes that have passed have specific provisions that say an employee cannot be discriminated against because they qualify for medical use. Florida does not have a specific provision that says that, but there are other states that have court decisions that say that an employee has the inherent power and the inherent right to sue for discrimination, even without that language in the statute, because the legislature decided to allow the use of medical marijuana. So if it's allowed to be used, then the mere fact that someone is a user should not be allowed to be a basis for not hiring somebody. But as I said earlier, if there's a reason to think that that person is in a sensitive position, they're a school bus driver, and they apply for that position, it may be that a school board has the right to say, we're not going to hire you for that position. Here's a list of other positions that are open, you can apply for these other positions. So we're in a state of conflict right now, and it's going to take a decade before these kinds of issues get resolved. You're not satisfied with my answer, but I can't.
It is not
You want, I'm gonna take a guess. You want a definitive,
Yes.
answer. You want the exact answer. And as you can tell from the vague comments that they're making, there are no bright line answers right now. The main point of having this presentation is to raise everyone's consciousness to the fact that everything's in a state of flux. When these issues come up, don't make an assumption that the old rules or the old approaches apply, because we're not in Kansas anymore. Toto. And I want to call you Toto. So how about we switch to sex, politics, and religion? Is that okay?
Yes. Yep.
All right. So, I asked that a couple of handouts be provided. I don't know if you have them. Were they provided to you with regard to the big dog ranch issue and the easing from my law firm, sex, politics, religion? Is that part of your package?
Yes.
no topic is off limit, times have changed. So the bottom line, the very simple point in the few minutes remaining is that employers have to be very careful about allowing an environment and a culture where employees get to either they have opportunities or they take advantage of opportunities to talk about issues that in the past, when we were all growing up, we were told, were things you're not supposed to discuss in polite company, sex, politics, or religion. Obviously, the list is a lot longer than that. But the point is that there are a lot of times represented where the employer imposes or expresses in a very firm manner the employer's position on certain issues. I'll give an example. The big dog ranch, I don't have to give the example, just tell you what happened recently. About a month ago, it turns out that this not-for-profit entity run by founder director allegedly announced that she would not allow any employees to come to work wearing Nike apparel, Nike sneakers. And it relates to the Cohen Kaepernick matters involving the NFL, where he took a knee and heel during the Star Spangled Banner national anthem. And as you know, it became and remains a controversial issue with President Trump weighing in and others weighing in. So it's a very hot, sensitive issue. He did so, he has explained, because of a protest against police brutality against African Americans, news stories of unarmed African Americans being shot by police, etc. And it was his way to express himself, and a very controversial issue because you had some people claiming on one hand generally that he has a First Amendment right in our country to express himself, and as does everyone. And others said it was unpatriotic, and there could have, would have, should have been different ways to express it without supposedly disrespecting the flag, the country, etc. So I'm certainly not commenting one way or another, trying to be make an objective comment about it. But if in your business all of a sudden that's being discussed, and then let's just say hypothetically half of the employees feel one way, I'm pretending there are only two general points of view on this thing, okay? Obviously there are more than that, and obviously I didn't express it so perfectly. But let's just say there are two halves among the employees, and they feel very strongly about it, and all of a sudden now you have issues of morale problems, you have issues, it spills over to clients, customers, you have an employer weighing in on one side or the other, and it's a potential, it can only lead to problems and trouble. So in this big dog ranch situation, this director said, I'm taking a position, and no employee is going to be allowed to come in and work wearing Nike apparel. If they have to give up their only pair of sneakers, I will buy them a non-Nike set. Those are the allegations that were made, and I think she walked back from them, and there was a question as to whether it was really the case or not, and then a lot of protests against her position, and I think she backed off, and I don't think that actually it was actually implemented. But it highlighted the fact that it opens up the employer to a lot of problems. And I gave an example. Let's just say the employees split 50-50, and all of a sudden, it's a week later or 2 weeks later, whatever the reason is. So that's an example, and I'm sure all of us can think of thousands of examples where other issues might come up. So, in that context, the employee would say, there's no reason to fire me, nothing changed in my performance, it had to have been because they took that position, and I wasn't being fired for political reasons, I was being fired because of racial reasons, because of a position I took on an issue dealing with race. And at that point, that employee might be in the protected category, and therefore a basis of cause of action might exist. So it's very hard to stop employees from discussing these kinds of issues, but there are employees who have policies and say that that's not going to be prohibited. We're not going to talk about hot button political issues or issues dealing with sex and politics and race and disability in any of the protected categories. And if you have personal opinions, keep it to yourself. There are employers who want to make sure that none of it shows up on the official social media of the company, and they don't want employees talking to clients and customers and others out in the public about their personal positions. I'll share one little issue with you. I'm probably the only one in the room, but I have an addiction to Costco.
I'm not the only one.
I'm not the only one.
No, not the only one.
So, and then we went to Costco. We made some friends there, right?
Yeah.
You see the same employees often, as I do, and it makes some friends. You know, they're nice people, and you know, they're very personable. So there's one woman, Marie, who's always giving out the free food. I'm probably the only one who makes friends with people giving out free food at Costco. So she pulled me aside. She's asked me for some help with her homeless association and her dog and whatnot. So it's a price I pay. There's no such thing as free lunch. So I have to talk to her about that. She pulled me aside and she said that they wanted to fire her because she was talking to a customer about her pro-Trump standing opinions, and another customer was standing there and heard and was so offended that the other customer complained to management, and this woman was told by management that she was forbidden to talk about political positions, and that if she did it again, she would be fired immediately. In that situation, again, on the assumption, on the hypothetical assumption that all of the Costco customers are split, it doesn't have to be 50-50, but let's just say they're split 50-50, and you've got people giving out food, and as you get the free meatball, you have someone telling you about their political positions. Well, it's the kind of thing that caused Costco to lose 50% of their customers, you know, by an exaggeration. So they have a policy that their employees are not allowed to discuss issues, those kinds of issues in the workplace with employees. So if you have a policy against it, if someone violates the policy, and then they get terminated for it, either right away or because you do progressive discipline, at least if they make a claim later that the real reason they were fired was because of discrimination under a protected category, you say, no, we actually had a policy, and you violated it 4 times, we wrote you up, and we told you not to do it, and there's a rational basis for a policy, and it had nothing to do with what your position was on that issue, one way or another. So that's the general point on that sensitive subject, and I'd be happy to, in a couple of minutes remaining, if there are, answer any questions or hear comments that anyone may have.
Any questions for
No
me?
one has anything to say about sex?
Not in the workplace.
I don't think it's ever a good idea.
Anybody? No one should do it? Just say no. I think,
Thank you, everybody. I enjoyed meeting with you again. I'm sorry I wasn't there in person. And you know I have a great affinity for Romeo and Paymaster. And I go through the same cases year after year. And I feel like I have a friendship with all of you, almost as much as my present customer.
thank you, Steve.
Thank you very much, Steve.
Yeah, as Romeo has told in the past, if you have questions or issues anytime, you can give me a call and don't worry about the meter running right away. I'm happy to be a resource as a courtesy to Romeo and Paymaster.
Thank you. All right.
We need a clapper.
It's called,
Okay, well, that's
see,
cool.
look at that.
Alrighty, well, I hope you all enjoyed Steve. Ooh, that's really loud, wow. Before we take a 10-minute break, there's a young lady in the back of the room who I'm going to ask to stand up by the name of Cindy Tate. She is our operations manager, and she does an amazing job putting this conference together every year for y'all. She works a lot of hours. She tries to make it beautiful and perfect, and she succeeds every single year. And she's a huge asset to Paymaster, as you all know. So we are very pleased to have Cindy here with us today, and thank you so much for all your work.